the argument of counsel has been captured in the body of the judgment, then the counsel for the defendant file a reply to the submissions of counsel for the claimant. The argument, the reply on point of argument on the reply on point of law also have been captured in the body of the judgment. So I will skip this. I will skip reading the argument. Counsel would see the argument when they get the hard copy of the judgment. Court decision. I goes to the court decision now. I have carefully perused the processes filed in this suit, as well as listening attentively to counsel for both sides in adumbration of their final written addresses canvassing the position of their respective clients. The counsel for the defendant formulated twin issues for determination, while the counsel for the claimant also formulated twin issues for resolution. The issues formulated are saying the same thing but in different tone. I am of the view that the issues can be submerged into a single issue which can conveniently resolve the dispute submitted by the parties before the court. The single issues formulated by the court is whether from the pleading and evidence adduced before the court, the claimant has proved entitlement to any of the reliefs being sought. The facts that led to the dispute between the parties are very simple and not complicated. The area of conflict or disagreement is very narrow. It is common ground that the claimant was a former employee of the defendant who served for 15 years and resigned his appointment at the age of 38 years. The claimant at the time of leaving service was by the exhibit CWD letter conveying acceptance of his resignation, was informed of his entitlement and his indebtedness to the defendant. The total indebtedness of the claimant was calculated to be the sum of 252,430 naira 61 kobo. This amount was deducted from the total entitlement of the claimants, leaving a balance of 323,062 naira and 92 kobo. This amount was paid to the claimant via a check which was tendered and admitted as Exhibit CWL. By the Exhibit E, the claimant wrote to the defendant expressing surprise for non-payment of his pension upon attainment of 45 years of age, which the claimant stated is the age at which he shall have the age at which he has become eligible to take benefit for the contribution he has made during his service years. However, the defendant failed and neglected to respond to the claimant's request for payment for arrears of pension and subsequently thereafter. The claimant is heavily relying on Exhibit CWA to CWL, tendered and admitted in evidence as his proof of entitlement to payment of pension as from 15th day of May 2007, when he claimed to have attained the age of 45 years. The age at which, according to the claimant, he shall be entitled to draw pension for contribution made during his service with the defendant. He relied on Exhibit CWH as his proof for entitlement to pension. The defendant, on the other hand, insisted that Exhibit CWA to CWL cannot establish claimant's entitlement to pension. Counsel refers to Exhibit CWD as evidence that the claimant had been paid all his terminal benefit and he has no claim to make against the defendant. Counsel posited that claimant has not adduced any evidence to the effect that at age 45 he shall be entitled to payment of pension. Let me say here that pension is a very important aspect of employment relationship, without which employment or service as employee will be of no benefit. This is because pension is provided for employee to enable employee who have served meritoriously enjoy the fruit of his labor. It also serve as means by which a retiree keep body and soul together at the time when he could not render any service, or engage in any income-generating venture due to old age. That's why the importance of pension cannot be overemphasized. Pension can therefore be considered to be a payment to an employee that is deferred until the employee is retired from service. The payment is usually regularly on monthly basis, like salary of workers. This means that pension is money that is retained or withheld by employer during the period of employment for the benefit of employee at the time the employee ceases to being able to work. That is to say, at reaching retirement age. Therefore, pension is the money that would have been in the hand of employee but is kept for the future utilization. Pension is income of an employee earned at retirement or upon discharge from service as considered for past contribution to the survival of an enterprise or community. It is the amount paid to employee after working for some specific period of time considered too old or ill to work and reach statutory age of retirement. It is a periodic, a regular sum paid to the retired officer until death or for stipulated period of time because the officer has worked with the organization paying the sum. As pointed out earlier in this judgment, the evidence adduced before the court clearly shows that Claimant served the defendant for a period of 15 years and he resigned his employment at the age of 38 years. The law is right. What is admitted require no further proof. See Ajib Asis Abba and others 2014 LPLR 24362CA. See Anthony versus I and I2 and two others. See also African Newspapers of Nigeria Limited, Dean versus African Newspaper, see Barrow and Consolidated, and host of other cases cited therein. I accept this as established. The area of disagreement is assertion of the claimant to the effect that from 15th of May 2007, when he clocked 45 years of age on earth, he was entitled to be drawing pension for the period of 15 years meritorious service rendered to the defendant. The claimant refers and relied on Exhibit CWB, Exhibit CWG, CWH, and CWK as what made him to be entitled to pension. I quite agree that Exhibit CWB, which is a letter transparent the claimant's service to that of established staff with effect from 1st of June 1984, and asking the claimant to complete dependents staff pension fund form and to accompany it with certificate of birth or age declaration for purpose of becoming a member of the fund with effect from 1st of October 1985, has established that the claimant with the completion of the form is eligible to contribute to the pension fund. Exhibit CWK, which is claimant's payslip, shows that pension contribution deduction was made from the claimant's salary in the sum of 252 naira 91 kobo. I also note that the sum of 80 naira was deducted for NSITF, that is National Social Insurance Trust Fund. I am convinced that Exhibit CWK, being payslip of the claimant for the month of December 1999, has established that the claimant is a contributor to the defendant's staff pension fund from 1st day of October 1985 to 30th day of October 2000 when his resignation took effect. See Exhibit CWD. The claimant has also been contributing 80 naira for NSITF. The claimant has, in his final written address, contended that the pension laws, Cap 346 laws of the Federation of Nigeria 1990, the then extant law governing pension in Nigeria, provide 15 years as the qualifying period for enjoyment of pension. Council also contended that all First Pension Act 1945, 1979, and 1990 provided the mandatory qualifying age at 45 to enjoy pension. Council further argued that the applicable law is the Pension Act of 1990, precisely Section 3, subsection 2 of the Act. Council submitted that the Act has provided that if a pension retiree, if a person retires before he is 45 years, he is still qualified for his pension. He only has to wait patiently until he reaches 45 years of age to begin drawing his pension. I have surveyed pension laws beginning from the Pension Ordinance of 1951, which was given retrospective effect from 1st of January 1946, which applies to government employees. I have also studied the National Pension Fund Act 1961, which was the first law to make provision for lump sum pension for employees of private organizations like the defendant. In 1974, an amendment was made to National Provident Fund Act, which withdrew public sector from its application and left the private sector. However, the National Social Insurance Trust Fund Act, NSITF, repealed the National Provident Act, C Section 42 of C Section 42, and transfer all its function to the board of NSITF. The above act pegged the retirement age to 60 years of age, but the organization concerned can ask an officer to retire at the age of 55 years, and he shall qualify to benefit from pension and other entitlements provided in the law and the regulations of the organization concerned. The claimant has insisted that the law has provided 45 years, but I have searched the law relied on by the claimant. There were no such provisions. The claimant has also not tendered the conditions of service made available to him as per Exhibit CWB, which would have provision for entitlement to pension for staff of the defendant. The failure of the claimant to tender any instrument which grants him pension is costly omission and fatal to his case. In labor law, claims for terminal benefit must be proved by reference to law that grants the benefit or the regulation governing the employment that grants such entitlement. The claimant, having failed to refer the court to any provisions in his conditions of service that grants him entitlement to the pension on attainment of 45 years of age after voluntary resignation before attaining such age, has woefully failed in his duty of proof. As the law remains, he who asserts must to prove his assertion. See Yusuf and another versus Mashi and others, 2015 LPLR 40754 CA. See also Mato versus Admiral Environmental Care Limited, 2015 LPELR 25905 CA. See also sections 131, 132, and 134 of the Evidence Act 2011. Exhibit CWH relied by the claimant cannot establish any claim for entitlement to pension. All that it established was that the claimant served the dependent for 15 years and no more. Exhibit CWH is only a certificate of recognition that the claimant has rendered loyal, faithful service, which is usually issued to enhance the chances of employee to secure another job in future after leaving service of the issuing organization. Exhibit CWG is equally a document that has no evidential value in the eyes of the law because it is unsigned. It is unsigned and has alterations in it. The law is well settled beyond reproach that a document that is not signed is worthless document. Omega Bank, C Omega Bank versus OBC 2004 or 2005, 1 SCNJ 150. It is also reported in 2005, 8 Nigerian Nuclear Report, Part 928, page 547. See also Jinadu versus Surombi Aro, 2009, 9 Nigerian Nuclear Report, Part 1145, page 55. See also Kelly and another versus Agba, reported in 2014 LPL Act 22653CA. The column for the commissioner for oaths was not signed. It was blank, no signature of commissioner for oaths. This document cannot qualify as declaration of age, as the commissioner for oaths has not attested to it. The non-execution of Exhibit CWG naturally affects the genuineness and validity of the said declaration of age. Therefore, Exhibit CWG being unsigned is hereby expunged for having been wrongly admitted in the first instance. It is also pertinent to refer to Exhibit CWE, CWF, and CWI. These are letters of request written by the claimant and his solicitors. These exhibits can only serve as proof that a request or demand was made regarding the claim of the claimant, but cannot establish or serve as proof of claim, which has to be done by credible evidence. These exhibits cannot be used as proof. They can only be used as to show request or complaint that has been made. From all I have been saying above, the claimant has not proved entitlement to any of the relief sought, for the simple reason that no iota of evidence has been adduced in proof of the assertion that at the age of 45 years, the claimant shall become entitled to payment of pension. In fact, the vital document that would have resolved this issue has not been tendered. That is the conditions of service of the claimant. The claimant has also erroneously, under argument 4.9 of the final written 4.9 of the final written address, attempted to introduce facts that are not contained in his pleadings. I quite agree with counsel for the defendant that no party is allowed to introduce facts that are supposed to be in the pleading in his final written address. Final written address is meant to assist the court in doing justice, but not for party to make a new case or give evidence. The argument in paragraph 4.9 of the claimant's final written address is hereby also expunged for being incompetent to be in that final written address. In the whole, the case of the claimant, crumbles for not having been established by credible evidence. It is hereby dismissed for lack of proof. I make no order as to court. Judgment entered accordingly.
As the court pleases.
Yes, call the next case.
Yes, my lord. Suit number NICN YL16 2019 between Alhaji Shaibu Bobo Hamid and 4 others, and the governor of Adamawa State and 4 others. My lord, the parties are absent.
Any appearance?
Yes, my lord. May it please, my lord, T.H. Chabu is my name. I appear for the claimants, my lord. T.H. Chabu is my name, my lord. I appear for the claimants.
Yes. Any other appearance?
Yes, my lord.
Yes.
I.S. Barde.
I.S. Barde.
Yes, my lord. Senior State Council Grade 2.
State Council Grade 2.
Yes, Adamawa State Minister of Justice.
Please, there should be no noise. We are in court sitting. Yes. Mr. Barde, appearing for who?
For the first, second, fourth, and fifth defendants, my lord. First, second,
yes,
fourth, and fifth defendant.
Yes. Any other appearance?
Yes, my lord.
Yes.
With the greatest respect, KJ Ndawalam is my
Yes.
name.
What?
KJ
KJ.
Ndawalam. Ndawalam.
KJ Idawalam.
Yes, my lord.
Yes. Are you appearing for
My
who?
humble appearance is for the third defendant.
Yes. Are you appearing with who?
My learned friend, B.U. Jada.
B.U.
Jada.
B.U. Jada.
Yes, my lord. For the third defendant.
This matter is for judgment. The judgment of the court
please.
is ready. The judgment goes like this. The claimants by a general form of complaints dated and filed on the 7th day of October 2019 commenced this action against the defendants. The general form of complaint was accompanied by a statement of fact, list of witnesses, witness statement on oath, list of documents, schedule of documents, pursuant to Order 3, Rule 11, and photocopies of documents to be relied on at the trial. From the facts as disclosed by the statement of fact and witness statement on oath, sometime in April 2019, the then governor of Adamawa State, Senator Mohamed Umar Jibrilla, based on approval of the State House of Assembly, appointed the best claimant as chairman and the best to fourth defendant as members or commissioners of first to fourth defendant, Adamawa State Civil Service Commission. However, shortly upon resumption of office of the current governor, Right Honorable Ahmadu Umaru Fintri, via a maiden broadcast on the 6th day of June, 2019, circulated to print and electronic media, suspended all appointments made on or after 28th day of March 2019, and dissolve all chairmen and commissioners or members of all commissions, boards of and parastatal in the state. The claimants challenged the decision of the first defendant to suspend and dissolve them in suit filed before this court in suit number NICN/YL/OL/2019. The judgment of the court was delivered on 18th day of September 2019, setting aside and nullifying the suspension and dissolution of the claimant's appointment. In flagrant disregard of the decision of the National Industrial Court, Yola Division, the first defendant sought for approval of the third defendant to terminate the appointment of the claimant on the grounds that due process were not followed during the selection, screening, and confirmation of the claimants as per the requirements of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The third defendant received the letter requesting approval to terminate claimant's appointment on the 6th day of August 2019. The third defendant on the 6th day of August 2019 approved the said termination the same day. The claimant stated that there has been no allegation of inability to perform the duties of their respective offices or misconduct level against them to warrant the termination of their appointment. The reason advanced for termination of appointment was untenable, and the earlier judgment of this court has held that claimants were validly appointed. The claimants stated that they have never been paid salaries and allowances since the date of their appointment. Today, the salary of the first defendant was given as 460,422 naira 6 kobo per month, while the salary of each of the second, third, and fourth, and fifth defendant was given as 453,165 naira per month. Based on the above facts, the claimant's claim against the defendant as follows. I shall skip the reliefs. One counsel is received the hard copy of the judgment. They will see the reliefs captured therein. Upon being served with the originating summons commencing this suit, the first, second, fourth, and fifth defendant filed a joint statement of defense wherein they denied any wrongdoing in terminating appointment of the claimant. The first, second, fourth, and fifth defendant insisted that the former governor, Senator Mohammed Umar Jibrilla, hurriedly and without observing the plurality and diversity of Adamawa State, with the approval of said defendant, appointed the claimant as chairman and members of the Civil Service Commission without following due process. They also stated that the termination of claimant's appointment was validly done as provided by law. It was also stated that there was no court order that was violated. The termination of appointment of claimant was due to non-compliance with the constitutional provisions regarding their appointment. The appointment of the claimant was in flagrant disregard of the Constitution of the Federal Republic of Nigeria regulating appointment of the claimant. It was stated that the appointment of claimants were not carried out in such a manner as to recognize diversity of people within Adamawa State, because out of the 5 appointments, 3 were from Adamawa Central Senatorial Zone, while the remaining 2 from Adamawa South Senatorial Zone, leaving the Adamawa Northern Senatorial Zone without any appointment. The first, second, fourth, fifth defendants counterclaim as follows. The counterclaim have been reproduced in the body of the judgment, so I will skip reading them. The claimant filed a reply to the first, second, and fourth defendant and fifth defendant statement of defense, wherein it was stated that the former governor was never in a hurry to appoint the claimant's appointment. It was equally not true that he did not observe plurality and diversity of Adamawa State as alleged, but that he strictly complied with the constitutional requirement, that there was no ill motive behind the appointment. There is nothing with their appointment reading 12th day of April 2019, oath of office 15th day of April, and letter of acceptance 16th day of April. It was stated that issues of validity of claimant's appointment and confirmation have been conclusively determined in suit number NICN/YL/OS/2019, which is the same issue the defendant are raising in this case. The parties are same and all previous and are bound by the decision in judgment of 18th day of September 2019 between the claimants and the first and third defendant on their previous. The issue of validity of claimants' appointment has been settled by this court in judgment of 18th day of September. The validity of claimants' appointment and confirmation vis-a-vis claimant suspension and decisions were the issues resolved in suit number NICNYL/OH/2019. The defendants are stopped from raising same issue in this suit. It was stated that said claimant is from Adamawa North Senatorial Zone by virtue of her marriage from Imubi local government area. The claimant insisted they assume office, but they were not allowed. They were suspended, prostrated, and suspended and dissolved. In the defense to the counterclaim, the claimant defendants to counterclaimant denied the counterclaim and insisted on validity of their appointment. They also raised plea of res judicata. The third defendant, with the leave of court granted on 12th day of November 2019, file its statement of defense out of time. In the statement of defense, the third defendant stated that the claimant's appointment were constitutionally terminated by the resolution of third defendant acting on the request of the first defendant. It was also stated that the claimants prior to the termination of the appointment never performed any official duty or attended office to warrant pay of any salary and allowances to them. It was also stated that the third defendant acted constitutionally in approving the dissolution of the claimant. It was also that there was no other national industrial court of Nigeria or any court whatsoever restraining the third defendant from dissolving the claimant. It was also stated that the third defendant by receiving a letter seeking to terminate appointment without any motive or intention to render order of court nugatory, as at the time the request for termination of the claimant's appointment was confirmed by the third defendant, there was no court order restraining the third defendant from so acting. The claimant's appointment were duly and constitutionally terminated on 6th day of August 2019 by resolution supported by members of the third defendant as required by the Constitution. Of the third defendant from receiving a communication 2020, the claimants testified to CW3, CW2, CW4, and CW5 respectively. They all identified their respective witnesses' statement on oath, adopted it as their evidence before the court. They also tendered documents and they were accordingly admitted in evidence. The documents produced by subpoena were tendered by counsel, and after overruling the objection by counsel for the defendant, they were also admitted in evidence as exhibit. The claimants were cross-examined by the counsel for the defendant after giving evidence in chief. Thereafter, they were discharged. On 14th day of December 2020, the Honorable Attorney General of Adamawa State, appearing for the first, second, fourth, and fifth defendant, tendered certified true copies of 2 documents which were admitted in evidence as exhibit DW1A and DW1B1-2, respectively. Thereafter, one Agre Ali mounted the witness box and testified in defense of the first, second, fourth, and fifth defendant as DW1. The witness, after identifying his witness statement on oath, adopted same as evidence in proof of the defense. Thereafter, the witness was cross-examined by counsel for the claimants. Thereafter, the witness was discharged as counsel for the third defendant informed the court that he has no question for the witness. When Yahya Danjuma testified in proof of the defense of third defendant as DW2, the witness identified his witness statement on oath and adopted same as his evidence in proof of the defense of the third defendant. DW2, after his evidence in chief, was cross-examined by the counsel for the claimants. Thereafter, he was discharged. The counsel for the third defendant tendered certified true copies of 3 documents in evidence. They were admitted in evidence and marked accordingly. At the conclusions of the testimony of the witnesses for the claimants and the defendant, parties were ordered by the court to file their final written addresses. The final written addresses were filed accordingly. The submissions of the first, second, fourth, and fifth defendant. The first, second, fourth, and fifth defendant formulated 2 issues for determination. They are whether the appointment of the claimant as chairman and members of the Adamawa State Civil Service Commission have complied with the provisions of Section 197(3) of the 1999 Constitution of the Federal Republic of Nigeria as amended, whether by whether by combined effect of the provisions of Section 1973, 14.4, and 5.2b of the 1999 Constitution as amended, the governor of Adamawa State has the power to remove members of Adamawa State Civil Service Commission from office. The argument of counsel have been captured in the body of the judgment. I will keep reading the argument. The submissions of the third defendant. The third defendant formulated a long issue to wit whether having regard to Section 201 of the 1999 Constitution, Federal Republic of Nigeria as amended, and the evidence before the court, the termination of appointment of the claimants can be constitutionally faulted to warrant their claims before the court being granted. Abubakar Saad, Esquire counsel that appeared for the third defendant in arguing the sole issue submitted that the claimants were appointed and removed in accordance with the Constitution, and there is no violation established by the claimants. The remaining argument of counsel have been captured in the body. I shall skip reading it. I go to the submissions of the claimants. The claimants counsel submitted two issues for resolution. One, whether the claimants are not entitled to the grant of the relief sought in the suit as per the pleadings and evidence adduced in support before the Honorable Court. Two, whether the first, second, fourth, and fifth defendants are entitled to the grant of relief sought by way of counterclaim as far as pleading and evidence adduced in support before the Honorable Court. The argument of counsel for the claimant have been captured in the body of the judgment, so counsel will have the benefit of reading it when they get the hard copy. I shall now go straight into the decision of the court. I have carefully considered the processes filed and the evidence adduced before the court by the parties in advancing their respective positions before the court. The facts of this case are straightforward and not much in dispute. From the pleadings before the court, the evidence adduced, the claimants in this case were sometimes in April 2019 appointed by the former governor as chairman and members 1 to 4 of the Adamawa State Civil Service Commission. This was sequel to approval given by the State House of Assembly, see Exhibit A, B, C, D, F, G, H, and K. However, upon assumption of office as executive governor of Adamawa State in May 2019, the current governor of Adamawa State, Right Honorable Umaru Fintiri, in a maiden broadcast to the state, circulated in both print and electronic media, suspended and dissolved all appointments made by his predecessor as from 28th day of March 2019 and thereafter. Dissatisfied with the action of the first defendant, the claimants instituted an action in this court in suit number NICN/YL/08/2019, wherein they challenged their suspension, and the court ordered that they were still in service of the defendant. While this suit number NICN was pending, the first and third defendant terminated claimants' appointment as claimant and members of the fourth defendant. This was done on ground of due process, were not followed during selection, screening, and confirmation of claimants as per requirements of the Constitution of the Federal Republic of Nigeria as amended. According to the claimants, their appointment having been made in line with the Constitution, the first and third defendant cannot, in the way and manner they did, terminate their appointment. They asked the court to hold that the termination of their appointment was wrongful and unlawful. For the defendants, it was stated that the first and third defendant have requested power to terminate the claimant's appointment as they did because the appointment did not follow due process as it was made in violation of the Constitution. It is null and void if it is as if nothing has happened. In determining this suit, I shall adopt the twin issues formulated by the claimants, as in my view, they have captured all the issues posed by the claimants and the counter-claimant under consideration. However, before delving into the issues for determination, it behoves on me to first and foremost rush one vital issue raised by the claimants. This issue is on res judicata or estupel. The claimants have in their pleading and in their written address stated that the defendant are stopped from raising the validity of the appointment of the claimant, as that issue had been earlier decided by this court in suit number NICN YL/08/2019. On 14th day of July 2021, in the process of adopting and arguing the final written addresses of the parties, A.K. Jingi Esquire, the learned chief law officer of Adamawa State, argued before me that the judgment in suit number NICN/YL/08/2019, which the claimant heavily relied to raise issue of estoppel, has been set aside by the Court of Appeal Yola Division. At the end of the submission of counsel for the claimant, after adopting his final written addresses, I urge counsel to react to the issues of setting aside of the judgment of this court by the Court of Appeal Yola Division, which they relied on in raising estoppel. In response, counsel agreed that that judgment had been set aside by the Court of Appeal Yola Division. In view of the foregoing revelation, the issue of estoppel raised by the counsel for the claimant has been overtaken by event. It has become a moot and academic issue, as the judgment thought to be relied on for estoppel to prove estoppel is no longer in existence. The setting aside of the judgment has rendered nugatory res judicata or issue estoppel relied by the claimants. The said judgment is no longer available for any purpose. In the circumstances, all the pleadings and submissions made regarding res judicata or issue estoppel based on the judgment of the court, based on the judgment of this court, which was set aside by the Court of Appeal Yola Division, are hereby discountenanced for the purpose of this judgment. I go to the resolution of issue 1, whether the claimants are not entitled to grant of the relief sought in this suit as per pleading and evidence adduced in support before this honorable court. The position of the defendant on the appointment of the claimant is that the appointment was made by the former governor, Senator Bindo Jibrila, where annullity in that the appointment was made where the appointments were made in violation of the Constitution. In support of this submission, reliance was made to the provisions of section 197198 and 2201 of the Constitution of the Federal Republic of Nigeria as amended. It was possibly argued that in making appointment of chairman and members of commission of the Civil Service Commission, the governor making the appointment must be guided by the diversity in the state and geographical spread. To buttress the point being made, the evidence of CW1, CW2, CW3, CW4, and CW5 under cross-examination were relied on. It was submitted that the appointments of the claimant made by the then governor of Adamawa State only from two senatorial zones was not properly made, because Adamawa Central Senatorial Zone has 3 candidates and Adamawa South has 2, while Adamawa North was left with none. It was also stated that only Muslims were appointed and people of other religions religious inclinations were not considered. This, according to counsel, violated the provisions of section 197, subsection subsection 3 and section 14, subsection 4 of the federal of the Constitution of the 1999 Constitution as amended. The third defendant made heavy weather on power of the first and third defendant to make appointment and terminate same. It was contended that the termination of appointment of the claimant was properly done, as the first and third defendant have been empowered by the provision of section 201 to terminate the appointment on the address of the House of Assembly, and the State House Assembly had, based on the request of first defendant, sat and deliberated and approved the termination. This, according to the third defendant, is in line with the Constitution. For the claimants, the termination of the appointment was done in violation of prohibitions of Constitution. It was also stated that the reasons given for the termination was not part of the restricted reason that the Constitution has allowed for termination. The claimants stated that they were never accused of misconduct or inability to perform or discharge the function of their offices, nor were they accused of non-diligence or incompetence in performance of their duties. It was also argued that Section 14, subsection 4 of the Constitution is not applicable, and that even if it is applicable, it is not justiciable by virtue of Section 6 of the Constitution. It is under Chapter 2 of the Constitution, which deals with directive principles. The counsel for the claimant also relied on the unreported decisions of National Industrial Court Judicial Division in suit number NICN/UY/25/2016 between Ekfuk Silas Udom versus Honorable Attorney General and Commissioner of Justice Adam Akwa Ibom State and one another, and the suit number NICN/24/2016 between Etim Sam Kaiso Okfo and Honorable Attorney General and Commissioner for Justice Akwa Ibom State and another. The judgments of which were delivered by Honorable Justice M.A. Namtari on the 17th day of June 2019, which according to counsel are on all fours with the instant case. In the latter case, it was stated that by the learned judge that Section 193 and Section 197, subsection 3 and 14, subsection 4 of the Constitution relied by the defendant as in the instant case at best. Section 14 and 197.3 are matters for consideration before appointment or constitution of any such commission. But once the appointment is made, the procedure under Section 201 must be complied with. Let me say here that unreported cases cited by the counsel for the claimant, which he claimed they were on all fours with the case at hand, have not been made available to the court. Therefore, they do not qualify as authorities to be relied on. It is right and well settled law too that where counsel relied on unreported case, counsel must provide the court with a certified true copy of the judgment sought to be relied on. See Oni versus Governor of Ekiti State. See also Chidoka and another versus First Finance Company Limited. See also Ugo in Ngadi versus FRN. For a court of law to rely on unreported case cited before it, counsel citing the unreported case has a bounden duty to supply the certified true copy of the judgment in question. Otherwise, there will be nothing to rely on. It is a good practice for counsel to draw attention of the court to its pronouncement in a previous decision, but the facts of the case to which the attention of the court was drawn must be same or similar before a decision in one can be used as guide to the decision in another. See Pawami versus NBA number 2, 1989, Fa Oputa JSC. It is also a well-settled principle of law that it is one thing to cite an authority and another thing to apply it to the case. Since a decision is only an authority for what it decides, nothing more, and each case is considered on its peculiar facts. See Skybank and another versus Akin Pelu. See also Adego Motors Limited versus Adesanya. The law does not permit making use of pronouncement of court in isolation of the facts and surrounding circumstances of the case to be relied on, and those of the case in view must be similar for the cases to be applicable. In the case at hand, as shown earlier, the parties are agreed that the appointment, tenure, and removal from the office of the claimants as chairman and members of the State Civil Service is as stated in Section 198 to 201 of the Constitution of the Federal Republic of Nigeria as mandate. In determining the appropriateness or otherwise of the appointment and termination of claimants' appointment, it is apt to make reference to constitutional provisions the parties relied on in making their cases. There is no doubt that the State Civil Service Commission Force Defendant in this case, to which the claimants were appointed as chairman and members, was established by the provision of Section 197(1)A of the Constitution of the Federal Republic of Nigeria, 1999, as amended. On the appointment of the claimants, Section 198 of the Constitution of the Federal Republic of Nigeria provide as follows: except in the case of ex officio members or where provisions are made in the Constitution, the chairman and members of any of the bodies so established shall, subject to the provision of the Constitution, be appointed by the governor of the state, and the appointment shall be subject to confirmation by resolution of the House of Assembly of the state. This means under Section 198, all that is required is for appointment all that is required is for appointment of the claimant shall be subject to shall be made subject to provision of Section 198 of the Constitution, and also any other provisions that relates to the appointment. However, for the defendant, the governor, who is the appointer, must ensure compliance with Section 14, subsection 4 of the Constitution in making the appointment. The claimant, on their part, insisted that the provisions of Section 14(4) of the Constitution is not applicable, and that even if it is applicable, there is compliance because the third claimant is married from Mubi local government area, which is in the Northern Senatorial District of Adamawa State, even though she is from Demsa local government area. By the Exhibit C and Exhibit D, DW1D, letter dated 9/4/2019, addressed to the Honorable Speaker, Adamawa State House of Assembly, the Governor of Adamawa State forwarded the names of the claimants to Adamawa State Assembly for confirmation or appointment as chairman and members of the State Civil Service Commission. Exhibit A shows that the State House Assembly confirmed approved the appointment of the claimant. This was followed by issuance of letters of appointment to the claimant. See Exhibit D, E, G, H, I, K, N, O, P, Q, and R. These letters enumerated the salaries and other entitlement of the claimant. It is clear from the above exhibits, the letter written to the House of Assembly, the vote of proceedings of the House Assembly, and letters of appointment issued to claimants that they were done. All these acts were done pursuant to Section 198 of the Constitution as amended. The question that need to be answered is, as the requirement of Section 14(4) of the Constitution is the requirement of Section mandatory to be fulfilled before an appointment under Section 198 of the Constitution be said to be valid? The defendants have maintained that the non-compliance or fulfillment of the requirement of Section 14(4) of the Constitution has rendered the claimant's appointment null and void and of no effect whatsoever. According to the defendants, the appointment of the claimants did not follow due process due to the violation of Section 14(4) of the Constitution, as the then governor who made the appointment of the claimants did not take into consideration geographical spread and cultural diversity of the state. According to the defendant, those appointed came from only two senatorial zones, i.e. Central Senatorial Zone and Southern Senatorial Zone, who were allocated 5, 3, and 2 slots, while the Northern Senatorial Zone was left with none. Encountering the position of the defendant, the claimant stated that there is no law requiring governor, when making appointment into the offices of the claimant, to take cognizance of the diversity or religion as suggested by the claimant. The claim by the defendant that due process was not followed in the appointment of the claimant raises the issue of validity of the claimant's appointment. I have earlier on in this judgment found that the appointment of the claimant was approved by the Adama State House of Assembly in line with the provision of Section 198 of the Constitution as amended, as the governor was made and the governor made the appointment thereafter. It is pertinent to reproduce the provisions of Section 197(3) and 14(4) of the Constitution relied on by the defendant as the section that were violated by the then governor when making the appointment of the claimant in this case. They are Section 1973. I have quoted it, no need of reading it. Council will see the provisions. I have also reproduced the provisions of Section 44 of the Constitution. The position of counsel for the claimant on the relevance and applicability of Section 14 is that provision is not justiciable because it was made under provision of Chapter 2 of the Constitution on directive principles. There is no disputing the fact that the provisions of Section 14(4) on their own alone without more is not justiciable. However, with the enactment of the Federal Character Commission Act, Establishment Act, this law has made the provisions of Section 14, subsection 4 of the 1999 Constitution as amended justiciable. So it is proper by raising it. Section 4 of the Federal Character Commission Establishment Act has made provisions for extensive function of the commission, which include working out equitable formula for distribution of all cadres in civil and public service of the Federation and state. The commission is also charged with the responsibility of promoting, monitoring, and enforcing compliance with the principles of proportionate sharing of all bureaucratic, economic, media, and political posts at all levels of government by the provisions of Regulation 6(2) of the subsidiary instrument made pursuant to the Act on guidance for distribution of public funds in state. Such appointment to the various public offices shall be done on the basis of the representation of the local government areas or senatorial districts of the state as appropriate, using the relevant formula. This means the local government areas shall have equal representation where the number of vacancies are less than the number of local government in a state. The appointment shall be made on equal representation from the three senatorial zone of the state. The Nigerian Constitution is the grand norm and is the sacrosanct, for it is from it that other laws are made, right created, and powers conferred. It is the source from which other tributaries emanate, and the 1999 Constitution of the Federal Republic of Nigeria, as amended, is the foundation upon which the democratic system of government we practice is anchored. It governs the relationship between citizen and government, and also defines our relationship with the other nation in this global village. It is therefore a document that must be appreciated, respected, and obeyed by all of us. The words in the Constitution are what convey the intention of the premise of the Constitution. Therefore, dispute or misunderstanding are bound to occur in the course of working with the Constitution. The lot is on the court to interpret the Constitution. In so doing, a court is duty-bound to consider in its entirety the relevant sections of the Constitution and statutes on the subject matter of dispute in order to arrive at the correct result, i.e., to decipher the intention of the premise of the Constitution. See the case of PDP versus INEC and others, reported in 1999, 11 Nigerian Weekly Law Report. See also Chime versus Ude, reported in 1996, 7 Nigerian Weekly Law Report, Part 461, page 379. See also AT Limited versus ADH Limited, reported in 2007, 15 Nigerian Weekly Law Report, where the court held that it is settled law that when a court is faced with the interpretation of constitutional provision, the entire provisions must be read together as a whole so as to determine the object of that provisions. In interpreting the Constitution, when the relevant provisions are read together, the words used is clear and unambiguous, must be given their plain and ordinary meaning. See the case of Fred Idigbe and Alhaji. See also Ojukwu versus Obasanjo. See also A.G. Bendel State. In A.G. Bendel State and Attorney General of the Federation, Obaseki JSA of blessed memory had formulated canon of interpretations. Those canons of interpretation have been reproduced in the body of the judgment, so I skip reading them. Applying the above quoted guidelines for interpretation to the case at hand, the relevant provisions of the Constitution, i.e. Section 14, 197, 198, 199, 200 and 201 of the 1999 Constitution as amended, as well as provisions of Federal Character Establishment Act with its subsidiary instrument, have to be examined, and a careful perusal of this provision will show that the correct interpretation of this provision is crucial to the determination of the dispute between the claimant and the defendant in this case. A careful consideration of the sections of the Constitution mentioned above and the Federal Character Commission Act, there is no escaping reaching the conclusion that in making appointment pursuant to Section 198 of the Constitution into the bodies established under Section 197(1)(a) of the Constitution, the governor making appointment must fulfill the condition precedent regarding federal character principles as it applies to state when making appointment. This inescapable conclusion must be reached when the Constitution and statutory provisions are holistically viewed and not giving a narrow or restrictive view. See Obayuwana versus Governor of Bandel State. As earlier observed, the appointment of the claimant was after confirmation by the House of Assembly, but the defendants are not asserting that due process was not followed. Now, the question arising from this assertion, but they are now asserting that due process was not followed. Now, the question arising from this assertion is that did the former governor acted within the powers conferred on him when he appointed the claimants on confirmation of the House of Assembly? The answer to this is in the negative. The reason being that the offices to which the claimants were appointed are offices regulated by provisions of Section 197 to 201 of the Constitution, in which case, apart from satisfying the provisions of Section 198, the governor is also mandated to ensure compliance with Section 14, subsection 4, as required by Section 197, subsection 3 of the Constitution, as well as the provisions of Federal Character Commission Establishment Act, which govern distribution of post, appointment, or filling of vacancies in the state. The fulfillment or compliance with Federal Character Commission Establishment Act is sine qua non before making appointment into the State Civil Service Commission. The requirement for compliance with Section 14 of the Constitution of the Federal Republic of Nigeria and the Federal Character Commission Act is condition precedent that must be fulfilled before appointment of chairman and members of the State Civil Service Commission can be said to have been properly or validly be made. In case at hand, the failure of the governor to adhere and complies with Federal Character Establishment Act has rendered the appointment of the claimant ab initio nullity. This is because the law requires composition of the chairman and members to be spread across the 3 senatorial zones of Adamawa State. But evidence adduced before the court clearly shows that only 2 senatorial zones, i.e. Central Senatorial Zone with 3 candidates and Southern Senatorial Zone with 2 candidates are beneficiaries, while the 3rd zone, that is the Northern Senatorial Zone, has no representation. And this court, there was nothing before me to show that there was no qualified person from this Northern Senatorial Zone to be appointed to occupy the positions or slot meant for the zone in the Civil Service Commission of Adamawa State. The counsel for the claimant has submitted that the 3rd defendant represented Northern Senatorial Zone because her husband hails from Mubi, which is in the Northern Senatorial Zone. This submission was based on gross misconception of law. The Federal Character Commission Establishment Act is very clear and unambiguous on position of married women when it comes to the issue of federal character. The law as it is today is that a married woman must claim her local government of origin or her senatorial zone and not that of her husband when it comes to appointment. It was in view of this, the issue of denial of Northern Senatorial Zone of their own slot in the State Civil Service Commission is glaring. In view of the above finding, the appointment of claimant was not done in line with principle of federal character. The appointment was done without requisite power. This means the reference, the defense put forward by the defendant succeed. Therefore, the claimants have failed to establish entitlement to any of the reliefs being sought since their appointment was ab initio null and void. I was strengthened in coming to the above conclusion when considering the fact that violation of federal character principles in making appointment is a criminal offense under our laws. From the evidence before the court, one does not need a soothsayer to be told that there is violation of federal character principle in the exercise that culminated in the appointment of the claimant. Although the law does not provide for selection screening, if it had been done, the costly mistake of making wrongful appointment would have been prevented. Therefore, I have no hesitation in holding that the process followed in appointing the claimant was fraught with irregularities to the extent that the infraction has rendered the entire exercise illegal for violation of the clear and unambiguous provisions of Section 197(3), 14(4) of the Constitution and the Federal Character Commission Establishment Act with its statutory instrument. The decision to hold that the entire exercise was illegal is based on the tried principle of law that court should not give effect to transaction which was forbidden by law. See Wari AC versus Moruku, 9 versus Moruku. See also the case of Adu versus Makanjola. See also the case of ACB versus Oladipo. See also John Chibas versus Davis of America Limited. All the citations have been provided in the body of the judgment. It is to be noted that Section 14, subsection 4 of the Constitution has imposed a duty on the governor in respect of compliance with federal character principles. Therefore, it is illegal to ignore such a duty enforced by the Constitution and statute. The governor the court will not condone such an illegality once brought to its attention. See the case of Wheeler versus New Maron Board Lease Limited. From all I have been saying, the claimants have not been able to convince this court that they were entitled to judgment in this suit, as they have not been able to show that due process was followed in their engagement by the governor, who violated the Constitution, which he swore to uphold and protect. The well-cherished federal character principle, which is a long-standing policy, government policy, is aimed at ensuring equality and equal distribution of force in it is a well thought out policy of government geared toward instilling sense of belonging among the ethnic nationalities cohabiting in the entity called Nigeria, the states and the local government areas. It will also serve as a means of cementing cordial relationship between various ethnic nationalities. It is also used as a vehicle to enhance peace and unity among federating units that made up the country, the state, and the local government areas. It is in view of the importance of this principle that violation of it should be deprecated. Also, that's why its violation was criminalized. The federal character principle is also in harmony with international best practice and ILO Convention 11, which prohibit discrimination of any type in employment. The federal character principles is equally in tandem with constitutional provision prohibiting discrimination. In view of the foregoing, this court cannot accede to the request of the claimants for granting them reliefs. To do so will amount to encouraging violation of extant provisions of the Constitution as amended and statute, which were made to ensure peaceful coexistence and sense of belonging by all and sundry. On the whole, the claimants have failed to prove their case. The claimants' claim failed and are hereby dismissed. On the counter-claim, having come to the conclusion that there was no valid appointment ab initio, it is not necessary to consider the counter-claim as it becomes a moot issue and overtaken by event. This is the judgment of the court. I make no order as to court. Parties to bear their cost. Judgment entered accordingly.
As the court previous.
My Lord, we are very grateful.
We appreciate, my Lord, with the industry puts. I would like to inform the Honorable Court that the former Attorney General, Adama said, joined us in the course of delivering the judgment.
Okay.
Sorry, I was before your learning brother.
You said?
I said I was before your learning brother in the open court doing a matter. And I tried to the judgment. I appreciate the judgment. We thank you for the industry. Thank you.
It's all right. You are welcome. Registrar, call the next case.
Yes, my lord. Suit number NICN YL 05-2018 between Mr. Emmanuel Peter Watana and the Federal Polytechnic, Nubi. My lord, the parties are absent.
That case, I have adjourned it. Registrar, that case you call is not before me. I have adjourned it to October.
Oh, my lord, on the diary.
Have you not communicated? I have adjourned it.
My lord, I'm sorry. I forgot to remove it from the course list. It's true, my lord. We've adjourned it, my lord. I'm sorry, my lord.
Yes, call the next case.
Yes, my lord. Suit number NICN ABJ 52-2018 between Mr. Lawrence Oga and Nigeria Turkish.
Yes.
No, the parties are absent.
Appearance? Any appearance? NICN ABJ? Yes.
Yes, my lord. KS Oloron Nishola, with due respect, my lord. KS Oloron Nishola.
Yes.
My lord, I'm appearing with my learned colleague, Moses Bisala Bature.
Are you appearing for whom?
My lord, we're appearing for the defendant. We humbly announce our appearance for the defendant.
Yes. Any appearance for the claimant? Any appearance for the claimant? Any appearance for the claimant? I am seeing one counsel, apart from Mr. Olo Rinishola. Okay, Mr. Ibanga, are you in this matter? Mr. Ibanga. It appears the claimant is not present.
As God pleases, my lord.
Counsel for the claimant. Yes, Mr. Olo Rinishola.
With profound respect to my noble lord, this case is listed for adoption of final written address today.
Yes, it is not even today. It has come before. None of you appeared.
We apologize.
About it came 2 times. None of you appears. In fact, my intention was if nobody appears today, I will just deem the addresses as having been argued.
Adopted. My lord,
yes.
aside that we have a live application, my lord, to regularize our position.
You have an application?
Yes, my lord.
Yes. Yes, Mr. Olori Nushola, go ahead. Go ahead with your application. Mr. Olorinishola, it appears you are frozen. Mr. Olorinishola.
Yes, my Lord.
It appears your network is very poor.
But I'm hearing my Lord loud and clear.
Yes. You can go ahead. I say you can go ahead and move your motion.
My Lord, the motion is filed on the 5th of February. 5th of February, 2021. It's
Yes.
filed. Okay, my Lord, on the face of the motion, we are praying, my Lord, the motion is brought pursuant to Order 57, Rule 4, Sub Rule 1.
Yes.
Another 17, Rule 1, Sub Rule 1.
Yes.
Of National Industrial Court of Nigeria.
Yes.
Rule 2007-17, and under the powers of this court, my Lord.
Yes.
My Lord, we are praying in this honorable court for the following orders.
Yes.
An order of this honorable court extending time within which the defendant applicant shall file and serve its final written address out of time.
Yes.
An order of this honorable court deeming the defendant applicant's written final address as properly filed and served.
Yes.
My Lord, and the third one is the omnibus application and for further orders, as my Lord may deem fit to make in this circumstance. My Lord, we have an affidavit attached to this motion, an affidavit of Moses Bature. My Lord, the affidavit is 9 paragraphs.
Yes.
We are placing a reliance on all the paragraphs of the affidavit, my Lord.
It's all right.
And my Lord, we also filed a written address.
Yes.
And my Lord, we want to move in terms of this motion, my Lord.
Yes.
And we urge your Lordship to grant our prayers.
It's all right. Application granted as prayed.
As the court pleases, my Lord. And my Lord, we also filed our final written address, the defendant's final written address.
Yes.
Dated 28th of January.
Dated
28th of January.
Yes.
2021.
Yes.
And my Lord, is filed on the 5th of February 2021.
Yes.
My Lord, issues were raised in the final written address.
Yes.
We have 2 issues raised.
Yes.
And my Lord, we are placing reliance on all the arguments.
Yes.
And all the rules, all the cases cited, and all our arguments, my Lord, we are placing reliance on all of them.
Yes.
My Lord, by way of adumbration, we want to stress.
Yes. Yes.
My Lord, we want to adopt this final written address.
Yes.
As our oral submission and argument in this case.
Yes.
My Lord, and we want to actually, by way of adumbration, my Lord.
Yes.
To state that this case is purely a master and servant relationship, my Lord.
Yes.
And aside that, my Lord, we want to point the attention of the court to paragraph 310. Paragraph 310, my Lord. Paragraph 310.
Paragraph 310.
Yes, my Lord.
Yes.
Especially exhibit.
Yes.
And especially exhibit CW1D.
Exhibit CW1D. Yes.
And exhibit CW1F 1 to 10.
Yes.
My Lord, we want my Lord to actually pay particular attention to that paragraph, my Lord. In that paragraph, it appears the counsel to the claimant want to mislead the court by actually removing each page from all the conditions of service.
You want to do what?
He actually pick pages from each condition of service from 2013, and they merge them together as a document to mislead the court.
He pick conditions of service.
Pages from each of them, from each year, 2013, 2014, and then 2016. They pick a page from each of the condition of service and merge them together as a document.
Okay.
This is an attempt to mislead the court.
That's another thing. You understand?
Yes.
My Lord, again, there's especially exhibit DW1F.
Okay.
My Lord, it's an admission. The claimant actually admitted by a letter of apology to the defendant.
Yes.
My Lord, from the totality of the facts.
Yes.
Pleadings and evidence, legal arguments, and all the cases before my Lord.
Yes.
My Lord, we are urging this honorable court
yes,
to answer the two issues formulated hearing for determination before my Lord.
Yes.
In favor of the defendant and dismiss the suit.
Yes.
In its entirety for being frivolous. My Lord, this case is very, very frivolous, vexatious, gold digging, and lack in merit. My Lord, as a matter of fact, the claimant want to make the shine of the court. They want to make the shine of the court, and this is an attempt to actually waste the time of the court.
Yes.
This honorable court is urged to so hold, my Lord, and may it please your Lordship.
Yes.
My Lord, that will be all, my Lord. That will be all.
Sorry. What happened to the claimant's address?
My Lord, we didn't know why he was not around today. I'm sure he was aware, maybe he set up somewhere, or maybe because of network.
Hey, what will happen to it? I know he's not before me now.
My Lord, we'll be applying for the court to deem the final written address of the claimant has been properly adopted before your Lordship, my Lord.
Okay.
May my Lord be pleased.
Yes. Yes, this case is adjourned to 18th of November 2021 for judgment.
Stop, please. My Lord, we are very grateful.
Yes. Okay.
Thank
you very much, Counsel, for your cooperation. We have come to the end of today's virtual sitting. Registrar, any other matter for virtual sitting for today?
No, my lord.
Okay,
No,
thank
my
you.
lord. Till next week, Friday, my lord.
We have come to the
Thursday.
end of today's sittings. Thank you very much. Okay. The
Thank you, my lord.
administrator, you can discontinue with the sitting. Okay.